Good morning. As you all know that we are supposed to discuss a very burning topic, that is delimitation and issues related to delimitation. Hope all of you know this one is English class. So I must clear first thing, this is English class. So if you want to see it, fine. If you don't want, then no problem, you can go. There is no problem. अगर आप में से किसी को जाना हो, अगर ऐसा लगता हो कि बाद में करेंगे, तो आप जा भी सकते हैं. ऐसा कुछ नहीं है कि मजबूरी में बैठना हो. ठीक है ना? यू वांट टू कंटिन्यू, बीच में नहीं उठना है बस. ओके. सो वी आर सपोज टू डिस्कस delimitation and related contemporary issues. Delimitation is a burning topic, and recently one special parliamentary session was called to discuss delimitation. And whatsoever happened, that also I will cover, but that will come later on. All of you know that India, after 75 years of republic, is entered in a very decisive phase of democracy. Democracy related international index is not very much positive, is not in our favor. Our liberal democracy as well as our electoral democracy, both are showing a very alarming deteriorating trend. And we are placed in a group of countries having electoral authoritarianism. So we are transformed. We are moving towards plutocracy from democracy. And that is a major issue in our country, that how from this stage we are going, or we will go, in what direction, in which direction, and what kind of strategy we will adopt. Because that will decide the future of Indian democracy. Of course, democracy is multidimensional and multidirectional. Democracy is used as a noun as well as adjective. democracy is classified as quantitative as well as qualitative. Today we are very much concerned about the nature of democracy whatsoever we will continue with in future generation, in future India. And one of the major issue that will shape Indian democracy in coming days is, of course, delimitation and the related issues of delimitation. I will discuss with you, as per the topic given, understanding delimitation, constitutional basis and contemporary concerns. And after that, of course, privilege motion will come. So first of all, I will discuss with you the concept of delimitation. Concept of delimitation. What actually delimitation is? Delimitation is very precise, accurate, scientific, methodological process to redefine, to re-establish the boundaries of constituencies in a given region as per the demand of demographic change. I will repeat, it is precise, accurate and scientific method to redesign, to redefine and to re-establish the boundary of constituencies, territorial constituencies in different regions as per the demand of demographic change. In India, delimitation is guided by constitutional provisions which mandate periodic reallocation of parliamentary and state assembly constituencies based on population changes. So very important thing is that the whole process of delimitation is regulated by, directed by, guided by constitutional provisions. Constituent Assembly tried to make the whole exercise of delimitation constitutionally correct to avoid any kind of politicization in our electoral democracy. In India, the delimitation related constitutional provision given in Article 82 of the Constitution for Lok Sabha seats and under Article 170 for state assembly seats. The question arises Why we should go for delimitation? If delimitation is precise, methodological, scientific process to redefine the boundary of territorial constituencies based on population, based on demographic changes. And for that, provision in Article 82 and 170 given by Constituent Assembly, question arises that why time and again we go for delimitation? What is the significance of delimitation of constituencies? For what a region we go for delimitation of constituencies every after census? Why demographic changes or population changes play an effective role or decisive role in electoral democracy? Then we find a very simple and clear answer, that in parliamentary democratic system we follow the formula of one person, one vote, one value. We follow the formula of one person, one vote, one value. It is very important for the country to go for delimitation after each census to ensure proportional representation in Lok Sabha and State Assembly by adjusting the number of seats based on population change. If number of seats will not be adjusted as per the demand of population change, and if country will not allow redefinition of boundaries, it will be difficult for the country to maintain that proportional representation. There are two things. When we will talk about significance, of delimitation, we will have to understand two basic things that delimitation will decide two. One, as per the demand of Article 81 of the Constitution, the total number of seats in Lok Sabha and at the same time number of seats each state will get on the basis of the population. So whenever population will change, not only number of seats is expected to be changed, but the boundary of constituency also may be changed. So first of all, number of seats, and second, redefinition of constituency's boundary. These are the two major things to ensure one citizen, one vote, one value. That's why delimitation is considered essential. Delimitation, when we'll go for the redistribution after redefinition of territorial constituency, will ensure the concept of equity. Hope some of you know that constitution makers had inserted the concept of equity in Article 14 of Indian Constitution. So delimitation is one specific methodology to ensure equity in political representation. Proportional representation we will get here, and equity we will get here. It means when political constituency will be redefined, the boundary will be redefined, then we will ensure equity. And when state-wise we will distribute the seats to get the total number of seats in Lok Sabha, we will get proportional representation. These two are very important for us to be careful about as far as electoral democracy is concerned, to ensure uniformity across the country in electoral provisions and electoral proceedings. Apart from these two, the third important factor that demand delimitation is reservation of seats for scheduled castes and scheduled tribes. We have in our constitution Article 330 and 332. Scheduled castes and scheduled tribes, how we will get a reservation? What will be criteria to get a reservation or to give reservation to scheduled castes and scheduled tribe people? That will be decided through the process of delimitation. These three are actually related to electoral democracy as such, more or less. But delimitation is not only going to decide the electoral framework. Delimitation is not for electoral provisions. When delimitation will decide proportional representation, when delimitation will decide equity, when delimitation will decide the reserved seats for scheduled castes and scheduled tribes, directly or indirectly, delimitation will pave the way for the functional federalism in our country. I am talking about functional federalism. Concept of federalism everyone aware about. But when I am talking about functional federalism, the whole process of delimitation will decide the nature of functional federalism. Because the delimitation will ensure uniformity across the country. And if delimitation will go in favor of any one state or any one region at the cost of other regions, the degree of federalism will be tilted in favor of one region or another region, and functional federalism will be in question. So delimitation is very important mechanism, and that's why I told you earlier, it is a highly precise methodological and scientific provision, criteria, mechanism to delimit the constituencies. if delimitation will not maintain the balance of power between union and state governments, if will not maintain uniformity across the country as far as horizontal balance is concerned, if states' representation in parliament will not reflect uniformity, straightway the very philosophy of federalism in our country will suffer. India is not a static federal country. Indian federalism is an organic one. Indian federalism is evolving a dynamic one. The process of delimitation demands uniform representation of the states at national level. And that must be reflected in the process of delimitation in our country. Apart from that federalism, delimitation is one another way to understand the nature of population growth in our country. Not only the nature of population growth, but the fertility rate and your related trend also are very important to understand. That if population will change, the process of delimitation will ensure representation of constituencies based on the current demography to check any kind of disparities. But at the same time, it will be essential for people of this country to understand that population increase in one area and at the same time decrease in one another area will create a number of problems. Because then proportional representation may not show uniformity. And that kind of problem will take place if in any country issue of delimitation will become a subject matter of debate. So, there is no doubt that delimitation, the whole process of delimitation is very much significant to ensure proportional representation, equity, functional federalism, reserve seats for scheduled castes, scheduled tribes, and fifth, population change or demographic changes. So, delimitation is important. That is very important to make our democracy viable, functional, dynamic, and responsive to the changing demographic pattern. And because of the significance of delimitation, India conducted delimitation exercise in 1960, 1951, 61, 71, and after that we freezed the process of delimitation in 1976 through 42nd constitutional amendment. When I am talking about 1951, 61, 71, that delimitation was directly related with number of seats in Lok Sabha and state assemblies. But we continued with the redefinition of constituencies in 2001 and onward, on the basis of population 2001. (1951) census, 1961 census, 1971 census. On the basis of 3 census, we changed the number of seats in our country. In 1952 delimitation, the cap of Lok Sabha seats was set at 500. And then on the basis of 1961, we increased 525. So 500, then 525. In 1973, on the basis of 1971 census, we came out with 545, and that was freezed through 42nd constitutional amendment. Now, question is that Delimitation Act 1952, Delimitation Act 1962, Delimitation Act 1971-72, 3 times we came out with exercise. We responded Article 81 and Article 82 both. We responded Article 170 also. But why we freezed the number of seats in Lok Sabha and state assemblies? First, in 1976, through 42nd constitutional amendment, and second, 84th constitutional amendment, 2001. Hope all of you know that 84th constitutional amendment freezed the number of seats until 2026. Now, question will arise in our mind that why we freezed. If we have provision given in 82, 170, 330, 332, of course 329 also is involved. Why we freezed? What were the reasons behind it? why we were forced to freeze constituencies. You will find that from very beginning, Union government was concerned about demographic changes in our country. Unfortunately, not uniformly. We found demographic changes or population change in north part of India different from southern part of India. Northern part was showing increasing population along with fertility rate, whereas south or southern states were showing reducing growth. That was the main reason behind the freezing of seats till 2026, with expectation that after 2026, to some extent uniformity will prevail, and then we will go for delimitation in a new way to readjust seats across the country and at the same time redefine the electoral territorial constituencies. That was the main reason. And you will find that our governments, how were concerned about the whole process of delimitation. And that will be reflected in different amendments in different time period to make delimitation relatively more meaningful in our country. I want to share with you 31st Constitutional Amendment Act. That 31st Constitutional Amendment Act 1973 inserted one provision that if population of one state will be less than 6 million, then population based delimitation exercise will not take place. I will repeat. States having population under 6 million means 60 lakh. If population will be less than 6 million, then that kind of states will be excluded from the delimitation exercise based on population. Region. States having less population also should be given due recognition and representation. So they were excluded. To check any kind of negative impact as far as electoral representation concerned in Lok Sabha. That was the first initiative taken by Union government in 1973. And then 1976, 42nd Constitutional Amendment Act. That 42nd Constitutional Amendment Act, as I earlier told you, freezes the allocation of Lok Sabha seats to states and division of territorial constituencies based on 1971 census. Till date we have 1971 census. So whatsoever population we had in 1971, on the basis of that we decided number of seats in Lok Sabha, and we came out with a decision to freeze it. That freeze was extended to state also. Earlier the same I told you. After that, 84th amendment came in 2001. 84th in 2001. Atal Bihari Vajpayee led government. Deliberately I am talking about Atal Bihari Vajpayee led government because this was eclipsed by emergency. So Atal Bihari Vajpayee led government in 2001 through 84th Constitutional Amendment extended the freeze. Extended the same till 2026. It was extended. Why it was extended? To maintain uniformity in population. As I told you earlier, we experienced uneven population growth in northern part in comparison to southern part. And not only southern part, northeast India also was showing a different pattern. So if you will compare with the northern part against the southern and northeast, you will find the population growth in northern part more than the population growth in southern part and northeast. So Atal Bihari Vajpayee led government decided to freeze it again till 2026. It means, in layman language, till 2026, number of seats will not increase. That will be based on census 1971. But as earlier I told you that seats were freezed, but delimitation of constituency in terms of redefinition of constituencies. Redefinition is different and number of seats are different. I want to clear here. Number of seats will be freezed means 545, at present 543. So 543 seats will not change. But when we will go for redefinition of the constituency's boundary, we can change as per the demand of new census. And 87th Constitutional Amendment was introduced. 87th Constitutional Amendment was introduced by the then Atal Bihari Vajpayee led government in 2003. 87th. 2003. And through this amendment, our government ensured that the basis of delimitation now will be 2001. Our basis of delimitation will be 2001. Be careful. This one will be related to 1971. Why 1971? Because 1971 census is used to decide total number of seats. Okay? Based on 42nd Amendment and 84th Amendment. And 87th Constitutional Amendment 2003 came out with a provision that basis of delimitation now will be 2001, not to increase the number of seats, but to redefine the constituency's boundary. Right? So in short, what we can write, 42nd and 84th, these two amendments were related to total number of seats, seats based on 1971 census, and 87th Constitutional Amendment related to redefinition of constituency on the basis of census 2001. So seats will not increase, but constituency boundary can be altered, can be changed, and that will be based on the census 2001. So these all show the successive governments at national level was very much concerned about fairer representation. And because of their concern, we found our governments came out with these all amendments, and with these all amendments, we decided finally to ensure fair representation, to ensure unity. So, in nutshell, I discuss with you the concept of delimitation. Number one. Number two, I discuss with you significance of delimitation. Number three, government's concerns regarding delimitation, and related amendments. I discuss with you 4 amendments, mainly 42nd Amendment, 84th Amendment, 87th Amendment, apart from 1973 where less than 6 million population were excluded. So governments were very much concerned about delimitation. And that was essential for governments to be concerned about delimitation in a country like India, to ensure federal philosophy, to give equal representation, to ensure fair representation, and to ensure equity as per the demand of Indian Constitution. Now question will arise in fourth. Who will be responsible for delimitation? Who will conduct a delimitation? who will do that? Because delimitation will not be by the government. For that also our constitution very much clear that through parliamentary law, one delimitation commission will be constituted. So now at this stage, I am going to discuss with you delimitation commission. At this stage, we are going to discuss delimitation commission. Everything clear or any doubt? Now delimitation commission. Delimitation commission. This delimitation commission is constituted by President of India. Is constituted by President of India. It is statutory, quasi-judicial body. Quasi-judicial body. And why statutory? Because Parliamentary Act will pave the way for the Constitution. Its the structure. Chaired by, it will always be chaired by either serving or retired Judge, Supreme Court. Then CEC, Chief Election Commissioner. Then concerned State Election Commissioner. Right? 3 members will be there. First, chaired by either serving or retired Supreme Court judge, then Chief Election Commissioner, then concerned State Election Commissioner. Apart from them, you will find associate members. Associate members, MPs, MLAs, selected MPs and MLAs of the concerned state. Selected MPs or MLAs of concerned state. There is no any fixed number how many MPs or MLAs will be included. But President of India, if think fit, then President of India can select members of Parliament of the concerned state, members of Legislative Assembly of that state. Okay? So that they will be called associate members. So that will be the composition of Delimitation Commission in India. And this Delimitation Commission in India is constituted with primary objective its primary objective is what? Primary objective is to ensure fair and equal representation. The primary objective is to ensure fair and equal representation by redrawing constituencies boundary, based on latest population. Its aim is to correct population imbalance because of change in population. Its aim is to correct population imbalance because of unequal or ununiform population changes. Its aim is to correct allocation of seats proportionately for scheduled caste and scheduled tribes, and this commission is responsible to improve administrative coherence. Commission is expected to improve administrative coherence of electoral divisions. So commission is responsible for redesigning or redrawing of boundaries, allocation of seats, reservation of seats for scheduled caste, scheduled tribes, and administrative coherence of electoral constituencies or electoral divisions. This commission is with different objectives I shared with you. This commission, constituted by President of India, adopt criteria, specific criteria for the delimitation of constituency. What is specific criteria? Some of you may know that Delimitation Commission is expected to take care of geographical compactness. The first point I am giving you, geographical compactness. First one is geographical compactness. Second one is population equity. Population equity. This one will be second criteria. Third one, natural boundary. Natural boundary. Fourth one, administrative convenience. Administrative convenience. Then fifth one, reservation of seats for scheduled caste, scheduled tribes, and sixth one, public feedback. Geographical compactness, population equity, natural boundary, administrative convenience, reservation of seats for scheduled caste, scheduled tribes, and of course public feedback. These are the specific criteria followed by Delimitation Commission. So again you will find this Delimitation Constitution, a commission is constituted by President of India. It's a statutory quasi-judicial body. Its composition is structure chaired by either serving or retired judge, Supreme Court, along with Chief Election Commissioner. Then concerned is State Election Commissioner and associated members. Objective I shared with you, I discussed with you, to ensure fair and equal representation by redrawing constituencies boundary. Second, allocation of seats. Third, you will find administrative coherence in electoral divisions. Then I shared with you specific criteria going to be adopted by Delimitation Commission. Now, the next part will come, the recommendation. A recommendation. Delimitation Commission, whenever will recommend whatsoever that a recommendation or that decision shall be binding in nature. It means the decision of Delimitation Commission shall not be challenged in court. It means Delimitation Commission will recommend whatsoever. Delimitation Commission will take a decision whatsoever that will not be a subject matter of judicial review. But here also, Supreme Court in 2024 had given a judgment. In 2024, Supreme Court in Kishore Chandra Chhaganlal Rathore, Kishore Chand Chhaganlal Rathore versus Union of India case. Kishore Chand Chhaganlal Rathore versus Union of India case 2024. Supreme Court categorically stated that Article 329, particularly 329A of the Constitution, also will come under judicial scrutiny. Kishore Chand Chhaganlal Rathore case is important. In 2024, Supreme Court in the same case categorically stated that Article 329 also will come under judicial review, and Supreme Court will review the delimitation order if that delimitation order will violate constitutional values. So when constitutional morality, when constitutional value will be challenged by Delimitation Commission, that will be scrutinized by Supreme Court, that will be reviewed by Supreme Court. So absolute blanket cover is not given to Delimitation Commission, particularly after 2024. And not only 2024, even in 2023, although matter is relatively different, in 2023, Supreme Court in Haji Abdul Ghani Khan versus Union of India case. Haji Abdul Ghani Khan versus Union of India case 2023. Supreme Court said that Delimitation Commission on one hand is authorized to go for redrawing of constituencies boundaries. Delimitation Commission is authorized to redraw constituencies boundary, but if delimitation will erode federalism, if delimitation will erode federalism or equality, or if will become victim of gerrymandering. So either federal philosophy or equality or victimization. I am talking about gerrymandering. Then Supreme Court will be allowed to intervene. So Delimitation Commission is not expected to do whatsoever want to do. Delimitation should not be against federalism, should not be against the concept of equity and equality, should not be a victim of gerrymandering. In later stage I will explain gerrymandering also. Should not be victim of gerrymandering. And at the same time, in 2024, in Kishore Chand Chhaganlal Rathore versus Union of India case, Supreme Court categorically stated that if delimitation will go against the constitutional values, the decisions taken by Delimitation Commission shall come under judicial review. So, Delimitation Commission is authorized. Prima facie, the decision of Delimitation Commission shall not be challenged in court, but Supreme Court had given a ruling in 2024. In case of violation of constitutional values, the decision or order taken by Delimitation Commission shall come under judicial review. So at present, come under judicial review as per the judgment of Supreme Court regarding Article 329. Article 329. So Delimitation Commission is responsible to delimit constituencies and redrawing of constituent boundaries in our country. Now, why today we are struggling? Why the whole exercise of delimitation is controversial one in India? Earlier also, in 61, in 71, we went for delimitation. We went for redrawing of constituencies on the basis of 2001 census. But why today we are struggling? Why today we are suffering? What are the major reason behind it? The major reason behind suffering. In last 5-6 years, southern states are raising voice against any kind of delimitation exercise post 2026. All of you know or should know that 106th Constitutional Amendment Act had introduced reservation for women in Lok Sabha, state assemblies and union territories. That was with some conditions, and conditions were very simple, that women reservation in legislature, popularly known as Nari Shakti Vandan Adhiniyam, will be enforced only after 2026 latest census. Because in 2021 we did not go for census. Reason was COVID. So after new census, women reservation will be enforced. I must clear here, because of political controversy, Women Reservation Act still is alive. In media, very difficult to know what were the narrow vendetta. But in media, it was given a big push, prominently highlighted that women reservation bill was defeated in Lok Sabha as far as 131st Amendment Bill 2026 concerned. It was not related to women reservation. I will repeat, it was not related to Women Reservation Act. Women Reservation Act still is an act and is enjoying constitutional provision. Women Reservation Act is entirely different from the whole exercise under the cloud of 131st Constitution Amendment Act. The whole act is different from the Women Reservation Act. I will repeat again, Women Reservation Act today even is active, live, and government, if will notify today, that act will hit the ground today itself. The enforcement of Women Reservation Act will not require political support in Lok Sabha or Rajya Sabha. It is already passed, and it was passed in 2023 again in a special session. So nothing to do with 131st Constitution Amendment Bill. And this bill already defeated in Lok Sabha now. is the reason behind spark or instigation or controversy behind the whole process of delimitation. Reason is very simple. Now I am talking about a recent controversy. Okay? Facts already shared with you. Now I am talking about a recent controversy. And a recent controversy starts with 131st Constitutional Amendment Bill. This is related with Constitution Amendment Bill. This Constitution Amendment Bill deals with 2-3 things. It is directly related to first Article 81 of the Constitution. It means number of seats should be increased. Then it is related to Article 82 and 170 of the Constitution. That is called Delimitation Bill 2026. This one is related to redrawing of constituencies. Then third, it is related to Union Territory Amendment Bill, UT Amendment Bill. So 3 parts are there. One is 131st Amendment Bill, that is related to Article 81. Second part, 82 and 170, means redrawing of constituencies. And third, UT Amendment Bill, related to reservation and readjustment of constituencies. 3 bills. Now, why these all are in controversy? Government said that we want to increase from 543 to 550 to 850. 550 to 850. 815 from states and 35 from UTs. That was the proposal. Second, that was very controversial. Here, actual provision is readjustment after each census. That is a provision, actual provision, to be amended. This one should be amended. Now, how to be amended? Readjustment of constituencies. Now, this one should be deleted. That is the complex issue. Our government was talking about what? That at present we have the provision readjustment after each census should be amended. How to be amended? Readjustment of constituencies. Readjustment of constituencies. It means after each session, not compulsory. Sorry, each census not compulsory. Census will be decided by government, by parliamentary law. It means if you are in power, with a simple majority, you can decide which census will be applicable where. At present constitution says what? After each census, irrespective of political party in power, it's a constitutional provision that you will have to redraw constituencies after each session. Now government was trying to do what? Government was trying to change the whole phraseology, that readjustment of constituencies after each session, that should be removed, and readjustment of constituency will be left out. Census part will be decided by parliamentary law, not by constitutional law. Because if constitutional law will decide to change the constitution, 2/3 majority will be required. If parliament will decide, simple majority will be required. So it will be easy for any government to decide the basis. And present government actually was trying to take this advantage. That not after each census, but up to the government to decide, up to the parliament to decide which census. That was a problem. As per the second part, is related to the readjustment of constituencies. The question is how to readjust. As per constitution, readjustment after each census. So constitution is very clear. If there will be census in 2021, readjustment will be based on 21. Constitution clear. But present government came out with a proposal that constitution should carry only one thing, readjustment of constituencies. Census will be decided by parliamentary law. It means which census will be base for redesigning, redrawing, parliament will decide. And parliamentary law will demand simple majority, not 2/3. So government was trying to dilute the provision Article 82 and 170. To take liberty, to decide census as per own wish, based on parliamentary majority. Simple majority. That was the main issue. It was not related to Women Reservation Bill, because the Women Reservation Act is intact. no one can change without changing the constitution. But our government said that we want to enforce Women Reservation Act. After amending this too, based on 2026 population, whatsoever expected population, or 2011 population, whatsoever expected population. That was the main reason behind southern states. They are opposing delimitation because of ununiform demographic change. So opposition was of the view that leave this one. This one will be decided on the basis of new census. Implement Women Reservation Bill Act within 543. And opposition inside the parliament said that we are ready to support government if government will come out with one amendment in Women Reservation Act related to census after 26. We are ready to amend that provision, because that provision is one reason behind late. So Women Reservation Act can be enforced even today after amending that clause. So opposition was ready to amend that clause to get that act implemented even day one. Then opposition said that why 33%? We want 50% reservation. Not only this, one member of parliament said that we are ready to support rotation-wise prime minister, one men and one male member, one female member. That proposal came from Trinamool Congress. We are ready to amend that. But government was not ready to amend Women Reservation Act to enforce the act. Women Reservation Act is still there, but government was concerned about this kind of exercise. And that's why that bill was defeated, because opposition was not ready to support these two mainly. And these two were related to this one also. So opposition unilaterally opposed. One another thing I want to share, that considering 2024 judgment, Kishore Chand Chhaganlal Rathore case, in Delimitation Bill 2026, Section 10, Clause 2, there was a provision that when delimitation will be published in Gazetteer, that order shall have the force of law and shall not be called in question of any court. It means Section 10, Clause 2 of Delimitation Bill talking about the order beyond a judicial review. It means whatsoever delimitation will be done, whatsoever delimitation act will come, that will not be allowed for judicial scrutiny. That was a provision in Delimitation Bill, section number 10, clause number 2. So government tried to make the delimitation recommendation outside the purview of judicial review. So, in nutshell, that delimitation bill or 134th Amendment bill was an attempt to influence Article 81, 82, 170 and UTs. I will repeat, nothing to do with Women Reservation Act, except in one thing, in one way, that Women Reservation Act will be enforced only after census. So opposition was ready to operationalize women quota after amending Women Reservation Act. After amending Women Reservation Act, that is already in Constitution. So opposition was ready to amend that. It is also very important for us to say that Women Reservation Act is talking about a rotational basis and for 15 years. There is a sunset clause also. Means Women Reservation Act which is passed is with some conditions, and reservation comes under sunset clause that is valid only for 15 years. After 15 years, like scheduled caste, scheduled tribes, it can be extended, but sunset clause is there, and as per sunset clause, for 15 years it is valid, right? And rotational basis also there. So the main controversy is this, related to bill. Clear? What kind of controversies? That 81 going to be affected. Government came out with a proposal 850. Although one another interesting fact, that when government came out with 850, initially government said we are talking about a ROPA model. ROPA means Representation of People Act model. So that was based on proportional representation. Opposition came out with the doubt that when you will come out with ROPA model, then southern states will be affected. Then government said that we are ready to include one provision that all states will get 50% more. Means whatsoever their seats, they will get 50% more. So suppose you have 40 seats, you will get 20 also, 60. Then opposition said nothing is written. Then Home Minister of India inside the Parliament said, give us 1 hour, we are ready to write it. But Union government was not ready to change these provisions, and that's why it was defeated. Now the matter is that why there is a big gap between states and states in South India and states in North India. This one is related to data only. So you will find almost everything we have covered. Last one I want to share with you data. North-South division and related data. Of course, we will not play data with data. 2-3 points I want to share with you. As of current projection, one MP in Uttar Pradesh is representing approximately 3.1 million people. and one member of parliament from Kerala representing 1.75 million of people. That is one data, almost half. 3.1 million people, one member of parliament. 1.75 million, one member of parliament. In that way, Uttar Pradesh is expecting more members of parliament. But it is not so simple. You will find north states, if we'll go for, or if we will allow any kind of change, then you will find that will be very complex for people to understand, because suppose number of seats unchanged 543. Suppose number of seats are 543. At present, based on 543, Uttar Pradesh is enjoying 80 seats. Right? Uttar Pradesh is enjoying 80 seats. If 2026 population will be based, this one is based on 1971. If 2026 will be projected, then seat of UP will increase, right? 226 base. Seat will increase, that will be approximately 91. It is only approximately, it is calculated on different bases. So it will increase 91. In that way, 11 seats will be more, right? But if number of seats will be 850, suppose 850, if will increase, then the 80 will be approximately 143. That 80 will be 143. Getting my point? When seats will be 850. If seat will be fixed 543, then based on 71, 80, based on 26, 91. If seats will be increased 81, article number 81, it will be 850. Then 26 will be applied and seat will increase from 80 to 143. That kind of change will take place and net gain will be 63. Getting it? When you will talk about Tamil Nadu, because Tamil Nadu in news, when you will talk about Tamil Nadu at present is enjoying 39 seats. Okay? Tamil Nadu is enjoying 39 seats. If 26 will be base, but seat will be 543, then Tamil Nadu will get 31. Reverse. Because population is, okay. In which case, when 543 will intact, there will be no change. But if 850 will be applied, 850, then number of seats will come to 49. Right? number of seats will come to 49. In that way you will find 10 increase. But here you are getting 63 increase. At present 80, 39. It means 41 difference you will find. There is a gap 41. But now you will gap, getting it? There will be 63 increase and Tamil Nadu getting only 10 increase. So gap will be widened. In that way, northern states will gain political mileage. And that will affect not only Lok Sabha, but Rajya Sabha also, State Assembly also, and presidential election also. So South states are against this kind of delimitation. And their contribution in GDP is 35%. In national growth, their contribution is 35% as far as South states are concerned. That's why they are opposing. That is very simple calculation. All the whole data, if I will go for analysis, it will take 2-3 hours. It's a simple data. That 1971 talking about 80 and 39, 543. If 543 will continue and population base will be changed 26, then UP will get 91 and Tamil Nadu will get 31. But if seats will change, will become 843, 850, then UP will get 143 and Tamil Nadu will get only 49. So that will be reverse growth. And if seats will not change, then Tamil Nadu will get minus. Enjoying 39 will get 31. Not only Tamil Nadu, West Bengal, Tamil Nadu, Kerala, Karnataka, Punjab, these states will have to lose. That's why these states are opposing. And that is a very clear division between union and this, north and south. That's why south states are against that. Now the question is, if south states will oppose, then in future there will be no any delimitation. Delimitation should not take place. Of course, delimitation will take place and must take place. But delimitation will have to take place only after addressing the problem. And this is not a problem of South India, but problem of Northeast also. Nagaland, Manipur, Mizoram and Meghalaya. These states are opposing. They are against increasing of number of seats. They are against amendment in Article 81. Not only this, my dear. We are struggling with one another problem. That problem is called the problem of gerrymandering. Problem of gerrymandering. I want to share with you, again it is not a government data, so that's why very difficult for us to say that the data we are sharing is actually based on the fact or not. But if I will talk about the issue of gerrymandering, you will find a deliberate manipulation. Gerrymandering in our regular classes I had discussed. It is a deliberate manipulation in redrawing of constituencies to give advantage to one party at the cost of others. And gerrymandering is very popular in United States of America. The term coined in 1812 in USA. As far as our country is concerned, Jammu and Kashmir, Assam, Uttar Pradesh, like states, are victim of gerrymandering. And you will find some states like Assam went for delimitation based on 2001. Jammu Kashmir went based on 2011. Union government took a decision. Number of constituencies like Barpeta in Assam became victim of gerrymandering. Number of constituencies are there. Considering the time, I am not in a position to cover all those constituencies. But constituency like Barpeta in Assam became victim of gerrymandering. So it is said Uttar Pradesh, Jammu and Kashmir, Assam like states were victim of gerrymandering in favor of one state at the cost of other states. So south states are not in favor of, or number of northeast states also are not in favor of any kind of change in the present status of constituencies. Their problems are very clear, that they have successful demographic control. Why they should be penalized? Why they should be punished? Why they will lose representation at national level, state level? Because that will be decisive in Finance Commission's report, that will be decisive in presidential election, that will be decisive in Rajya Sabha election. So everywhere, south states and northeast states will be undermined or will be dominated by north states. So they are against that. And if south and northeast will be dominated by north, it will be against the federal philosophy of the country. Because federalism will demand all states equal and uniform. So, south states are against it. But north states are talking about it's a democratic, it is a demand of the constitution, women are supposed to get representation. But one very interesting fact, when we are talking about women who are expected to get representation, why members of parliament are not ready to give representation only within 543? Why they want to increase number of seats to give representation? It means they are not allowing any touch to 543. If we are ready to give representation to women, we can give representation in 543 itself. Why seat increase will be attached with women representation? We have given reservation to women 33%. 33% of 543 should be given. There is no requirement to increase the number to 850. So why government is talking about 850? That is one another problem. So essential for us to be careful about that sensitivity of the problem. And if India is going through that kind of problem, a very clear division between north, south and northeast, we can go with the pattern across the world. And you will find pattern across the world since 1913. The number of seats in House of Representatives is capped 535. 1913 till date, USA did not allow to increase the number of seats in House of Representatives, that is Lok Sabha in India. And since 1913, they have only 435. They did not increase. Whereas population in 1911 in USA 9.4 crore. 2023 population 33.4 crore. So 9.4 crore 1911 and 33.4 crore in 2023, but they did not increase number of seats in House of Representatives. When you will come to European Union, they have a principle of regressive proportionality. They have principle of regressive proportionality. That is a very unique kind of principle. Principle of regressive proportionality. Regressive proportionality means, in simple language, if your population will go up, number of seats also will go up, but regressive proportionality. Suppose your population is 100, you got 10 seats. Tomorrow your population is 150, does not mean you will get 15 seats. You will get 12 seats. So regressive proportionality. If you will increase your population in the same proportion, seat will not increase. Regressive. And one day that may be negative, because you have increased level of population. It is called principle of regressive proportionality. In European Union they have. So number of examples you will find in different countries, in different kind of provisions they have, and they are going with that kind of provisions. Right? In Australia they have a population based constituencies. But whenever Delimitation Commission will come out with any recommendation, that will be reviewed by judiciary. That will not go unchallenged. So there will be no any kind of dictatorship in deciding constituency or number of seats. Now, what we should do? It is said that India should go for hybrid model. India should go for hybrid model, and hybrid model is what? When we will go for hybrid model, then it will be easy for us to divide seats on the basis of population and at the same time on the basis of the development. On the basis of population and on the basis of development. So states having more development should get more seats, less population should get less seats. So hybrid model ultimately will ensure uniformity. So development criteria as well as population criteria should be taken care of. Total fertility rate, Human Development Index, economic contribution, as I told you, 35% of GDP from South. So economic contribution, Human Development Index, fertility rate, these all should be taken care of rather than population only. And if these all will be taken care of, then there will be no division, more or less, between North and South and Northeast. I must give emphasis on one thing, that India is a cooperative federal country. And in cooperative federalism, no area of the country can be allowed to dominate. No area can dominate any area, either north or south or northeast or northwest, any. Cannot dominate and cannot be allowed to dominate. There must be uniformity. At the same time, states having more population who are not controlling population should not be given any kind of political advantage. That will go against the federal philosophy. So it is essential for us to come out with hybrid model. And when we will come out with hybrid model, then human development index, economic contribution from the state, and the fertility rate, this all will be taken care of, and that will give more or less more scientific criteria to deal with delimitation in our country. So it is not so easy to come out with delimitation based on the majority rule. Predominance of any area will not be allowed and will not be welcomed in the country. It will affect Indian federal philosophy, and when Indian federal philosophy will be affected, then directly or indirectly our unity and integrity also will suffer to some extent. So very important for us to be careful about the sensitivity of delimitation in our country, and hope some of you know that under leadership of former Chief Minister, now Stalin, or at present he is Chief Minister. So Chief Minister Stalin, some states came together and passed a resolution against any kind of delimitation. Karnataka, Kerala, West Bengal, Punjab, all are against delimitation. So we must be careful about the all issues related to delimitation and quantitative analysis of delimitation, right? So this one will not be so easy to be careful about it. Data will be very precise, and government is not very clear. 850 will be there, 543 will be there, or 816 will be there. In some data, Indian Express, you will find 816. In Hindu, you will find 848, right? So different datas are there because of his speculation only. So I took a data to explain how states will suffer and how some states will get benefit of that, right? So on the basis of this all, we can come to the conclusion that delimitation is very serious issue, and delimitation should not be taken lightly. That may backfire, and we should be careful about delimitation. We should come out with hybrid model. That hybrid model will pave the way for consensus between north, south and northeast. So it is not a debate or dialogue between north and south. It is north, south and northeast also, because number of states in northeast are getting problem, or they are on disadvantaged position because of their population growth less, and their of course population very low. You will find Sikkim's population very low, enjoying 1 or 2 seats more or less. So in that way we must be careful about delimitation. And before going to wind up the session, I must tell you that 131st constitutional amendment practically and factually had nothing to do with any kind of Women Reservation Act, because Women Reservation Act is intact, and Women Reservation Act can be enforced even today, and within the limit of 543 if parliamentarians will be ready to implement. So being a student, we should not be confused with the delimitation and the Women Reservation Act. Women Reservation Act still is valid and ready to be enforced. It will be up to union government to enforce with a very simple amendment, and for that amendment, as per opposition, they also are ready to support government. Clear? So this is all about delimitation issue, constitutional basis and contemporary concerns. I hope you are benefited. And now privilege motion. You may be surprised that why with a burning issue of delimitation, we have accommodated one another topic, that is privilege motion. It is not to cover the rest half an hour. We are supposed to complete the session in 2.5 hours. So this is not an attempt to cover the time. Hope some of you know that one opposition leader, Venugopal, has given a notice of breach of privilege against the Prime Minister of India. Prime Minister of India, after defeat of 131st Constitution Amendment Bill, decided to address the country. And when decided to address the country, was not a big issue, not a matter of surprise, because Prime Minister is entitled to address the nation. But when Prime Minister addressed the nation, he criticized the opposition. That is a breach of privilege, according to opposition. Because Prime Minister, no Prime Minister is expected to enter in electoral politics when addressing nation. Addressing nation is different from Man Ki Baat. Addressing nation is different from electoral discussion, debate and speeches. In national speech, when you are going to address the country, you are supposed to be confined to governmental activities only. You are supposed to be confined to governmental initiatives only. You are not supposed to enter in any kind of narrow politics. This is not my view. This is a view of opposition. And that's why opposition came out with privilege motion against the Prime Minister of India. Now the issue is like other members of Parliament, Prime Minister also is enjoying privilege. And hope you know that Article 105 of the Constitution gives the provision for privilege motion as far as Parliament is concerned. Privilege motion is related to the privileges given to members of Parliament. Privileges and immunities make parliamentarians out of the domain of Article 14 of the Constitution also. They are immune to Article 14. They have some specific rights, and they enjoy those rights and freedom being a member of Parliament to perform their respective duties. So, when we are talking about privilege motion, should be discussed in two ways. The first one, the concept, and second one, constitutional provisions. Concept is what? Authority must be in proportion to responsibility. Authority must be in proportion to responsibility. Members of Parliament have more responsibility than the citizens of India. They represent every corner of the country. They represent each and every citizen of India. In fact, they are voice for the people of this country. So, being a parliamentarian, they will do their duty only after getting some specific privileges. Their rights should be more, their authority should be more than others. That's why special privileges are given to them, specific rights are given to them. And when I am talking about specific rights, these rights are not to glorify them. These specific rights or privileges are not for self-aggrandization. These rights are to ensure the dignity of members of Parliament, independence of members of Parliament, to make them functional in nature. They are supposed to be effective in functioning without any kind of legislative hurdle or the functional hurdle. That's why they should be given some sort of special privilege. For example, and hope you will not take otherwise, we are here to discuss with you number of provisions, number of subjects, number of topics. So out of a sudden, that should not be, but out of a sudden, or because of unintentional thinking, something may come out that should not come out. But if that will come out, and I will be liable before court of law, then I will not take any chance, I will not take any challenge to discuss with you whatsoever I am here to discuss. I must be given some sort of liberty, I must be given some sort of extra right to deal with the current environment. Similarly, members of Parliament are delivering their speech inside the Parliament. Unintentional statement if they will give and will be booked, they will face rule of law, then why they will take challenge? Why they will represent people of this country? They will not. So functional independence is very important. And functional independence, when will be given? members of parliament, and of course members of legislative assembly also, they also will get benefit. Benefit not to be self-aggrandized, but to serve people. So article number 105 and 194, these two are very important as far as the privilege is concerned. So conceptual interpretation is one, constitutional provision is another. Constitutional provision, article 105 and 194, right? And you can take 122 also. 122 parliamentary proceedings are beyond judicial review. So that also you can take. And if you will take 122, you can take 212 also. 212 assembly proceedings will be beyond judicial review. So 105 and 194, 122 and 212. Okay? 105 along with 194 and 122 along with 212. These are the provisions for us. Now, privilege, special privilege, parliamentary privilege actually originated in India during British time. Charter Act 1833 first time, and then Government of India Act 1935. Charter Act 1833 and then Government of India Act 1935, major source or origin of parliamentary privileges. I will repeat, 1833 Charter Act and 1935 Government of India Act. In our country, along with constitutional provisions and historical legacy 1833 and 1935, we have parliamentary convention, the third one, parliamentary convention, judicial interpretation and judicial judgments, and then statutory laws. It means apart from constitutional provision, we have historical legacy along with parliamentary convention, then statutory law, and then judicial interpretation. So source of parliamentary privileges you can divide into these all parts. First one, historical legacy, then constitutional provisions. Apart from constitutional provision, these are the sources. So one source is historical legacy, then constitutional provision, article number 105, 194, 122, 212. Then you will find parliamentary convention, then you will find statutory law, law passed by parliament, and then you will find judicial interpretation. So these are related to parliamentary privileges, right? And parliamentary privileges are extended to all members of parliament along with Attorney General of India, hope you know, along with Attorney General of India and President of India, because President of India also is a part of parliament. So Attorney General of India and President of India both are enjoying the same kind of privileges members of parliament enjoying. Now, these privileges technically are divided into two parts: individual privileges and collective privileges. Okay? Individual privileges and collective privileges. What is individual privilege? Members of parliament have a right to speak on the floor of the house. They must be allowed to speak, and when they will speak, they will not come under Article 14 or 19 of the Constitution to be booked. So they are allowed to perform their responsibilities as per their own individual right. members of parliament have a right to be exempted from judicial inquiry during parliamentary sessions. They will not be forced to, or they will not be summoned to judiciary to come as a witness or to give evidence. They will enjoy freedom from arrest also, 40 days before, 40 days after. They will not be arrested within the premise of parliament without getting consent of his speaker. They will not be arrested, or they will not come under judiciary. Collective responsibilities you will find based on privileges. Without consent of members of parliament, no stranger will be in parliament. Parliamentary proceedings will not be published if will not get consent of the parliament. Whenever member of parliament will be arrested anywhere in the country, after detention, authority will have to inform Speaker of the House the time as well as the place. Then you will find, as per privilege, they can go for secret sitting. It means media will not be allowed to cover their sittings. They may go with the disciplinary power, as article number 19(2) of the Constitution says. If there will be any kind of defamation to parliament, parliament can summon anyone and will be authorized to give punishment. So members of parliament collectively enjoy that kind of power. If anyone will defame, if there will be contempt of parliament, not defame, what is wrong, if anyone will go for contempt of parliament, then parliament is enjoying authority to punish those people who are responsible for contempt of parliament, and that provision is given in the Constitution itself, article number 19(2). So number of collective provisions are there, number of individual provisions are there. I will repeat that these all provisions are given to members of parliament not to glorify self, but to perform as a member of parliament. So in nutshell, in short, they are not allowed to use those parliamentary provisions, constitutional provisions or parliamentary privileges to misuse that. They are not entitled to use those parliamentary privileges to satisfy their own narrow interest. And if they will go for that kind of thing, then privilege notice will be invited. And that privilege notice is in use because of K.C. Venugopal of Indian National Congress has served notice against the Prime Minister of India, because Prime Minister of India misused parliamentary privilege when he addressed the nation. And parliamentary privileges are for members of parliament inside the parliament, not outside the parliament. Whatsoever privilege given inside. If I have some sort of privilege, that privilege is within the classroom. Outside the classroom, I don't have that privilege. Whatsoever I am telling you inside the classroom, the same privilege will not be given to me outside the classroom. In the same way, parliamentary privilege is given to members of parliament to perform inside the parliament, not outside the parliament. So Prime Minister of India, if going to address the nation, will breach the parliamentary privilege, may attract a notice, and notice was given to him considering the wrong or misuse of parliamentary privilege. It is against the Prime Minister, because Prime Minister tried to malign the image of opposition according to K.C. Venugopal. Right. Now, being a student, essential for us to know that privilege notice can be given to the presiding officer of the House. It is a formal notice. Any member of Parliament can submit that notice against the breach of privilege. Against the breach of privilege. It means violation of all those privileges whatsoever given under Article 105 or 194. It is used to initiate action against the member or outsider. So who is member at present? Prime Minister of India. And action should be taken against the Prime Minister of India. That will be the subject matter of privilege motion or privilege notice. Right? In Lok Sabha, we have rule number 222. I will repeat, in Lok Sabha, we have rule number 222, and in Rajya Sabha 187. In Rajya Sabha 187, in Lok Sabha 222, following these rules, members of Parliament can introduce privilege motion or privilege notice against the member of the House or against any outsider. Apart from that, when member of Parliament will put that notice formally, presiding officer, either Speaker Lok Sabha or Chairperson Rajya Sabha, will go for scrutiny. This is a very crucial point, that when presiding officer will receive that notice against any member of Parliament or outsider, will go for first level inquiry or scrutiny. It is called primary level scrutiny. And primary level scrutiny simply means, as a layman, that presiding officer will examine the correctness of claim. Whosoever presented or submitted that notice, whosoever going to blame, in this case Prime Minister, Speaker Lok Sabha is authorized to examine that whatsoever charges are mentioned, really these all charges are valid or not. Who will decide? Presiding officer, means Speaker of the House. And when Speaker of the House will decide, yes, these are the valid charges, then will admit the motion, otherwise will reject the motion. So admission of the notice will be based on the primary scrutiny by Speaker. If Speaker will reject the notice, that notice will be lapsed then and there. If the Speaker will accept the notice, will admit the notice, that notice will come. But here also, 25 member support will be required. But that will be the third stage. Suppose you came out with privilege motion against me, then Speaker of the House will go for scrutiny. If Speaker will consider the charges correct, then 25 member support will be required. After 25 member support, that notice will be considered, and that notice will go to Committee of Privilege. Committee of Privilege. And Committee of Privilege will be with the 15 members from Lok Sabha and 10 members from Rajya Sabha. 25 members will be there in Privilege Committee. 15 from Lok Sabha and 10 from Rajya Sabha. They all will be nominated by Speaker and Chairperson. Try to be careful. That Privilege Committee going to be constituted 15 nominated by speaker and 10 nominated by chairperson. Nominated, not elected. So speaker will nominate 15 and chairperson will nominate 10. So all 25 members shall be nominated by speaker and chairperson. And most of the time, speaker and chairperson will belong to the party in power. And Prime Minister is head of the government. So whatsoever charges are framed against the Prime Minister, that charge will be examined by the Privilege Committee, manned by nominated members, Speaker Lok Sabha and Chairperson Rajya Sabha. Now question is, as per the rule, as per the philosophy, committee is expected to go for free and fair scrutiny. Free and fair scrutiny. This committee will come out with finding, and whatsoever finding that will be presented before the speaker or the chairperson. And then they will decide punishment will be given or not, breach of privilege took place or not. If not, then person will not be punished. Either member of parliament or outsider will not be punished. Right? So the question is very clear, that whosoever will charge government or Prime Minister, Privilege Committee manned by nominated members hardly will criticize the party in power. Outrightly no one can reject, but hardly it will be possible that Privilege Committee will go against the Prime Minister of India, or leave Privilege Committee. The presiding officer, speaker, will go against the Prime Minister of India at the first level. Difficult to digest. So whosoever has submitted notice, that notice will not go beyond speaker level. First level is speaker's level. Then when will be admitted, 25 member support, and then we'll go to Privilege Committee. Privilege Committee will be manned by 25 members, 15 from Lok Sabha, 10 from Rajya Sabha. They all shall be nominated. Okay? They all shall be nominated. Okay? So this kind of Privilege Committee we have privilege motion, and any member of parliament can come out with privilege motion, either in favor or against, right? Member of parliament or outsider. But what is the procedure? Again, before going to conclude, procedure is what? Any member of parliament can come out with privilege notice. That notice will be given to presiding officer of the respective house, right? And then the presiding officer will go for primary labor scrutiny. If presiding officer will find its charges correct, then we'll admit that notice. Once that notice will be admitted, for discussion, 25 member support will be required, right? Then the charges will go to Privilege Committee. Committee will be manned by 25 members, 15 from Lok Sabha, 10 from Rajya Sabha. All are nominated by the presiding officers respectively. Respectively means 15 will be nominated by Speaker Lok Sabha, 10 will be nominated by Chairperson Rajya Sabha, and they will go for examination of all those charges, will come out with their finding, will submit report. On the basis of report, decision will be taken, or disciplinary decision will be taken. This provision or this kind of proceeding hardly will give any kind of ruling against the Prime Minister of India as per the political culture in our country. Not as per the provision. They can go against the Prime Minister of India. But as for the prevailing political culture, very difficult to say that this kind of privilege notice will go beyond the speaker level, but can go beyond the speaker level. Okay, there is no any procedural hurdle, so can go against the President, Prime Minister of India. Okay, so this kind of thing came in news because of K.C. Venugopal. So we are supposed to be concerned about privilege motion because in pre also they may ask you a question, and of course in mains they may come out with a question because privilege motion not against any member of parliament but against the Prime Minister of India. So they can come out with that kind of question, right? And I had in my class discussed with students that privilege motion, parliamentary privileges whatsoever given to members of parliament are highly misused, and that's why codes of conduct are considered essential for members of parliament. We don't have codes of conduct in Lok Sabha, we have codes of conduct in Raj Sabha. So all those provisions related to codes of conduct and in Lok Sabha and Raj Sabha in classes I had discussed with you. So today I will confine myself to the privilege notice given to Prime Minister of India and related points, right? In next session I may come out with a new topic, new burning topic. So wait for that time. Thank you very much. Thank you.